and welcome to HR Talk, People Management's regular discussion about the topics making the news in the HR world. I'm Jill Evans and I'm joined this week by Martin Warren, a partner and head of the HR practice group at law firm Eversheds. The country is facing an unprecedented level of strike threats, most of them prompted by proposed changes to public sector pensions. There have been a number of calls to tighten the laws regulating strike action, including a suggestion for a 40% threshold for a strike ballot. And recently there's been a private member's bill put into Parliament suggesting this threshold should be raised to 50%. Trade unions complain that the current rules are overprescriptive and almost impossible to comply with. So are we likely to see reform of the strike laws in the near future? Martin, what do you think?
Well, although we've had many threats of strikes in the past few months, actually days lost through industrial action remain very low. And the government has made plain that if it does legislate, it'll legislate in response to industrial action, not in advance of it. So I wouldn't expect any change to the law for at least 18 months.
So Martin, what sort of changes do you think we might see?
I think if the government looks at this area, they will work on the basis the law was constructed in the 1980s. That's before the age of the internet, mobile phones, BlackBerry messages, etc.
Right.
And the way employers communicate, the way trade unions communicate is dramatically different. So I think the law needs to be updated to take account of the way technology has moved on. There are also significant ambiguities in the current law, which I think if the government does legislate, it will look to clarify.
Can you give me an example of an ambiguity that you're thinking of? No?
Well, there's an ambiguity has recently been introduced by the Court of Appeal decision in Serco, which contradicts what is written in the statute. So I think if the government does look at the law, it may well look to clarify the law post-Serco and effectively partially overrule Serco.
If these changes were to become part of the law, would it alter the way that employers respond to strike threats, do you think?
If the changes become law, then it will make it slightly more difficult for trade unions to organise industrial action, not materially more difficult. Employers' contingency planning will remain broadly the same. Two broad themes that an employer should think about. One is communicate with their employees in the run-up to a ballot, look to persuade employees to vote against the industrial action. If that's not possible, then the employer has to contingency plan and work out how they're going to cope and maintain their supplies to their customers or their service to their customers during the action.
Do you think there's any particular advice that public sector employers would do well to look to in the coming months?
I think look to engage with employees. I think it's very easy for an employer in a situation where a trade union is campaigning to sit back and almost allow the trade union to communicate with the employees. I think the employer should always bear in mind that it has a voice, and often employees want to hear from the employer as well as from their trade union. And if they're only hearing one side, they're not getting the full version of events. Thanks
again for joining us today. Keep up to date with the latest HR news at peoplemanagement.co.uk. And until next time, goodbye.